judgment in the Queen against McCool and the Queen against Harkin.
Lord Kerr will give the judgment to the court.
Donna McCool and James Harkin were married when Ms. McCool was charged with and pleaded guilty to 4 offences of obtaining benefit by fraud. These were of false accounting on the 26th of September 1990 for the purpose of obtaining income support as a single person when, as I've said, in fact, she was married. She made a false declaration to similar effect on the 28th of November 2003, another false declaration on the 20th of October 2005, and again on the 10th of August 2010. Mr. Harkin pleaded guilty to making a false declaration on the 16th of December 1999 in relation to an application for income support, representing that he was single when in fact he was married to Ms. McCool. He pleaded guilty to other offences, 2 of which were similar to the first offence in December 1999, and the remainder were in relation to housing benefit. All of the cases to which Ms. McCool pleaded guilty, except one, had been committed after the coming into force of the Proceeds of Crime Act of 2002. Most of the offences to which Mr. Harkin had pleaded guilty had also been committed after the coming into force of that item of legislation. Section 156 of the 2002 Act provides for the making of orders to confiscate benefits obtained by criminal activity. And the principal issue in this appeal was where applications were made for confiscation orders in respect of offences committed after the 2002 Act came into force, and where the persons against whom the applications were made had also been convicted in the same proceedings of offences committed before the coming into force of that Act, the applications in respect of the post-2003 offences had to be dealt with under legislation which preceded the 2002 Act, or whether they could be dealt with under the regime that was introduced by that legislation. That issue required that stipulations in the relevant commencement order, which make provision as to when the 2002 Act applies, be considered and applied. The Court of Appeal in Northern Ireland had held that the regime under the 2002 Act could be applied to offences which had been committed after that Act came into force, even where the persons against whom the orders were to be made had also been convicted of offences committed after the Act had come into force. That court refused permission to appeal to the Supreme Court, but it certified a point of law as being one of public general importance, and I needn't read that out. This court, the Supreme Court, gave permission to appeal, and by a majority of 3 to 2, it dismisses the appeals of Ms. McCool and Mr. Harkin. The appellants had argued that the wording of the commencement order is such that where a defendant is committed for a number of offences, where any of those offences had been committed before the commencement date, then none of the offences could be dealt with under the 2002 Act. And the majority concluded that this would produce an anomalous result. In my judgment, I said that the overarching consideration is that it was Parliament's intention, first, that offences committed before the commencement date should not be included in the Section 156 consideration, and secondly, that offences committed after that date, which could generate confiscation orders under the Act, should be dealt with under that section. I concluded that it could not have been intended that a number of post-2003 offences should be removed from the scope of the 2002 Act simply because the defendant was convicted of an associated offence before the commencement date. The consequence of the 2002 Act being disapplied to a wide range of offences committed after the commencement date and requiring them to be dealt with under earlier legislation, I considered to be undesirable. Contemporary cases would have to be dealt with according to standards and rules which have been replaced. And I also considered that it wasn't necessary to read words into the statute in order to achieve that result. Lord Hughes agrees with my judgment that it is not necessary to read words into the statute. He considers that the differences between the earlier legislation and the 2002 Act, and he concluded that the key question was whether the construction proposed by the Crown would result in any unfairness to the defendants. He gave it as his opinion that if it would or might, then the principle that penal statutes must be construed strictly in favour of those penalised would carry considerable weight. But in the event, he concluded that there was nothing unfair in saying that the appellant should bear the confiscation consequences of post-March 2003 offences as required by the 2002 Act, unless those consequences differed in some way from what they would have been if they had not committed the earlier offences, which in his judgment they did not. Lady Black agrees with Lord Hughes. Lord Reid, with whom Lord Mance agrees, dissents. His view is that the language of the provisions cannot be interpreted as excluding offences which the prosecution had elected to leave out of account for the purpose of assessing the benefit obtained by the defendant. In the event, however, because of the judgments of the majority, the appeal is dismissed.
The Court will adjourn for a short moment.